Welcome back to the deep dive. We're continuing our journey through the MPEP, the Manual of Patent Examining Procedure. Right now we're in Chapter 1200, Appeals.
That's right. And, filing an appeal feels like a big step towards finality, but sometimes, well, the case takes a bit of a detour.
A U-turn even, and that's exactly what we're digging into today, isn't it? MPPA Section 1211.
Yep, Section 1211, remand by director or board. Basically, remand just means the case that gets sent back downstairs, so to speak.
Back to the examiner. From who?
From either the director of the USPTO or, more commonly, the Patent Trial and Appeal Board, the PTT, or just the board, as most people call it.
Okay, so today's mission is really to unpack that. Why does a case get remanded during appeal? How does it actually happen procedurally? And crucially, what does it mean for you if you're the appellant?
And what happens once it is back with the examiner? That's key, too.
Right. So the basics first. Why remand?
Fundamentally, it's usually because something needs another look, more examination, or some specific point needs further consideration.
Yeah.
It's all governed by rules like 37 CFR 41.35 and 41.50.
Okay. And you mentioned something important right off the bat in the source material.
Oh, absolutely critical. A remand order itself, it's not considered a final agency action.
Meaning
You can't appeal the remand itself. You can't argue to a higher court, hey, they shouldn't have sent this back.
Okay, so you just have to deal with it. If my case is remanded, what happens then, practically speaking?
Your focus has to shift immediately. The legal authority over the case transfers from the board right back to the examiner.
And the examiner just picks it up.
Well, they have to act based exactly on what the remand order says. They need to be totally consistent with those instructions.
What if the order is vague? Like, reconsider?
If it doesn't give super specific instructions, then the examiner follows the procedures outlined back in MPP Section 1207, which covers reopening prosecution after an appeal.
Gotcha. Can you give us an example? When might the director step in and remand?
Sure. The source gives one scenario. Imagine there's a significant change in patent law while your appeal is pending, something that requires a new ground of rejection to be applied.
Oh, okay.
The director might remand the case specifically for that. And in that situation, the examiner's next step is pretty clear. They'd issue what's called a substitute examiner's answer, and that answer would include the new rejection based on that law change.
Right, that makes sense. Definitely changes the game mid-appeal.
It really can.
Okay, before we dive deeper into the different types of remands, just want to say a quick thank you to Mike Shepard. He's the creative director who pulled this whole audio series together.
Yes, thanks, Mike. And also, our usual but very important reminder.
This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It's for general educational and informational purposes only. It is definitely not legal advice or a substitute for formal instruction.
Please, for authoritative guidance, always consult the official MPEP, talk to a qualified instructor, or, of course, a registered patent practitioner.
All right, let's crack open Section 1211 properly. Section 1211.01. This seems to be about remands, specifically for considering rejections.
Exactly. This part focuses on when the board remands for further consideration of a rejection under 37 CFR 41.50A1. Now, in these cases, the examiner might issue a substitute examiner's answer.
Might.
They have the option. And here's the really crucial part for you, the appellant. That substitute answer could introduce a completely new ground of rejection.
Whoa, hang on. So the board sends it back maybe to reconsider rejection A, and the examiner comes back with rejection B instead, or maybe A and B.
It could happen. They might refine the original rejection, or they might add a totally new one based on their further consideration.
Okay, that feels like a curveball. What do I have to do then? What are the consequences?
This is where you need to be really alert. There's a very strict requirement
Right.
to stop your appeal from being just flat out dismissed.
Dismissed. Wow.
Yes. You must file a response within 2 months. That's 2 months from the date the substitute examiner's answer is mailed.
2 months. That sounds really fast compared to normal office action response times.
It is fast. And here's the kicker. The usual extensions of time you can get under 37 CFR 1.136A, they do not apply here.
No extensions on.
None. It's a hard deadline. Miss it, and your appeal is dismissed. Period.
Okay. 2 months, no extensions. What are my options within that 2-month window?
You have exactly 2 choices laid out right in the rules. Option 1, You can file a reply under 37 CFR 1.1111. This basically says, okay, let's reopen prosecution. You're taking it off the appeal track and going back to regular examination with the examiner.
All right, and option 2?
Option 2, you request that the appeal stays alive. You do this by filing a reply brief under 37 CFR 41.41. And that brief has to specifically address every single new ground of rejection the examiner raised in that substitute answer.
So it's a strategic choice. Argue with the examiner again, or take the fight straight back to the board about the new rejection.
That's the decision you face. And there's a really important detail if you pick option 2, the reply brief. If you file that reply brief, but you also include, say, new evidence like a declaration, or you try to amend your claims.
Ah, I was wondering about that.
Right. If you do that, the rules say it gets treated as if you chose option 1. It's automatically considered a request to reopen prosecution.
So no sneaking in new amendments or evidence if I want to argue the new rejection directly to the board? Doing that forces me back to the examiner anyway.
Precisely. The thinking is new stuff needs the examiner's review first, so submitting it signals you're willing to reopen.
Okay, that's a critical distinction.
It is. And it's also vital to realize this whole 2-month, 2-option framework applies only to these specific remands, the ones under 41.581, where a new ground of rejection can be introduced.
So not all remands trigger this.
Correct. The board might remand for other reasons. The source mentions, for instance, maybe just to make sure the examiner considers an information disclosure statement, an IDS that was filed, or maybe to review a reply brief you filed that raised some other issue.
Okay.
In those cases where there's no new ground of rejection being brought in under that specific rule, that strict 2-month deadline and the 2 specific response options, they just don't apply.
So understanding why it was remanded is absolutely paramount.
It should be more important. The reason dictates the procedure.
That clears things up a lot. Now, what about amendments more generally? Can I try to tweak my claims while the appeal is up at the board?
Good question.
Yeah.
That leads us to section 11211.02. The general rule, the board is not obligated to consider amendments you submit while they have jurisdiction.
They can just ignore them. Seems a bit tough.
They have the discretion. It's not the time for substantive prosecution. However,
There's always a however in patent law, isn't there?
pretty much, the board can decide to remand the case specifically so the examiner can review an amendment.
When might they do that?
The source gives examples, like if your amendment cancels claims altogether, or if it rewrites dependent claims into independent form. Those kinds of structural changes might prompt a remand for examiner review.
Okay, so certain types of amendments might get sent down?
They might. It's the way those amendments could potentially get looked at after the appeal process is started. But there's a warning here, too.
Which is?
If the amendments you file basically signal you're giving up the fight on appeal, say, you cancel all the claims that were actually rejected and under appeal.
Then there's nothing left for the board to decide.
Exactly. In that case, the board will usually just dismiss the appeal. Why remand if the core issue is gone?
Makes sense. Be careful not to accidentally abandon your appeal. Okay, what about evidence, affidavits, declarations? Can I submit those during appeal?
Section 1211.03 covers that. And surprise, surprise, timing is absolutely crucial here.
Timing again? Okay, lay it out for us.
Right. If you file an affidavit or declaration after the final rejection, but before the board officially takes jurisdiction, sort of in that transition period, they can be considered, but only if you, the appellant, can show 2 things. 1, that the evidence is necessary, and 2, that you couldn't possibly have presented it earlier during regular examination.
So you need a good reason for the delay. Can't just hold back evidence.
Pretty much.
Yeah.
Diligence is key. Now, what if you file that affidavit or declaration after the board already has jurisdiction?
Let me guess. Harder.
Much harder. It's extremely rare for the board to consider that kind of late-filed evidence.
How rare is rare?
Almost never. Unless,
Yeah.
and here's that pattern again, unless the board specifically remands the case for the purpose of having the examiner consider that affidavit or declaration.
So remand is, again, the gateway for getting new stuff looked at late in the game.
Generally, yes.
Yeah.
For both amendments and new factual evidence like declarations, once the board has the case, a specific remand is often the only path for consideration.
Right. Okay, one more section here, 11211.04. This one sounds unusual. Remand just for more searching.
Yeah, the source calls this a rare scenario. A remand issued only for the examiner to conduct further searching.
Why rare? Seems like finding the best art is always good.
It sounds good, but think about the stage. The case is already on appeal. Sending it back just for more searching causes delays, it's inefficient, and, as the source points out, it could even mess with your patent term adjustment.
Ah, the PTA implications. Okay.
So the board needs a really compelling reason to do this. It's not done lightly.
What kind of justification would they need?
Typically, they have to be pretty specific. They'd likely need to identify particular classification areas, maybe even cite some existing art, and explain why they believe a targeted search in those specific areas is necessary now. It's not just go look for more stuff.
Got it. Targeted and justified. Okay, so we've walked through the main reasons for remand. Potential new rejections, reviewing certain amendments, maybe looking at late filed evidence, and this rare further search scenario. Let's tie it all together. Why is mastering MPP 1211 so important if you're appealing?
Because, fundamentally, a remand isn't just a pause button. It actively changes the procedural posture of your case. It kicks in specific rules, deadlines like that critical 2-month one we talked about, and forces strategic decisions.
And knowing the type of remand tells you which rules apply.
Absolutely. Is it the kind that could bring a new rejection and that hard deadline? Or is it for something else, like an IDS, where the procedure is different? That knowledge dictates your required actions, your available options, and the potential consequences, like dismissal.
So this isn't just, MPP trivia. Understanding Section 1211 gives you a kind of procedural map for these potential detours during appeal. It helps you know what you must do and what you might be able to do.
Exactly that. It's about anticipating possibilities, avoiding pitfalls like missing that non-extendable deadline, and making informed choices to keep your application moving forward, even if the path isn't quite straight.
This deep dive into MPP 1211 has definitely highlighted how complex yet structured the remand process is. We've seen it's not just one thing. The reason for the remand, whether it's about rejections, amendments, evidence, or search, really dictates everything that follows.
And nailing down those distinctions is crucial. That 2-month no extensions deadline for responding to a potential new rejection under 41.50A1 is probably the single biggest takeaway in terms of immediate risk if you're not aware of it.
It really emphasizes needing to read that remand order incredibly carefully, which brings up a final thought, maybe. How do you strategize for an appeal knowing these remand possibilities exist? Like, you don't want to submit evidence too early if it's not needed, but waiting too late means you might only get it considered if the board decides to remand for it. I feel like a bit of a balancing act.
That's a great point. Balancing diligence during prosecution with the realities of what can and sometimes can't be easily introduced once you're on appeal.
Yeah, that's definitely something to mull over when planning your overall strategy.
Food for thought, indeed. Okay, let's wrap up. We want to thank Mike Shepard again, the creative director for this whole MPEP audio series.
Yes, thank you, Mike. And one last time, the necessary disclaimer.
This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only, and is not legal advice or a substitute for formal instruction.
For authoritative guidance, please consult the official MPEP, a qualified instructor, or a registered patent practitioner.